Okay, we're going to get started now. Good afternoon, everyone, and welcome to the third installation of the Alliance Defending Freedom American Culture on Appeal Symposia series. Alliance Defending Freedom is the largest religious freedom nonprofit law firm in the world and advocates for the rights of people to freely live out their faith. I think everyone would agree that in these last few years, religious freedom has become both a legal and cultural hot topic in a way that we haven't seen for quite some time. We personally, ADF, have had several religious freedom cases before the Supreme Court, and I know all of our panelists have been involved in these cases as well. So this idea for this series was born out of just looking at these cases and seeing how they were every other day on the front page of newspapers in some way or another, and I thought we should all come together and examine as a group some of the most interesting and certainly some of the most pressing issues of our time. Today's first panel will examine the only religious freedom case the Supreme Court has agreed to hear thus far, although, as all the reporters especially know in the room, we are still waiting for them to schedule oral arguments. And that's the Trinity Lutheran playground case. The second panel will be a general discussion on taking the temperature of the Supreme Court on religious freedom. So we're going to have a discussion on what's going on there exactly. As Justice Alito said in his dissent in the cert denial for Stormins, an ominous sign. And others say, well, no, it's not. We're doing okay. So that will be the second panel. Throughout the panel discussions, we invite you to join the conversation by using hashtag SCOTUS and tweeting at Alliance Defends. Our moderator for our first panel is Adam Liptak, the Supreme Court correspondent for the New York Times. Adam is an attorney who joined the Times news staff in 2002 and began covering the Supreme Court in the fall of 2008. He has written a column, Sidebar, and Developments in the Law since 2007. Adam's series on ways in which the United States legal system differs from those of other developed nations, American Exception, was a finalist for the 2009 Pulitzer Prize in Explanatory Reporting. During law school, Adam worked as a summer clerk in the New York Times Company's legal department. After graduating, he spent 4 years at Cahill, Gordon & Rendell, a New York City law firm, as a litigation associate specializing in First Amendment matters. In '92, he returned to the Times' legal department, spending a decade advising the Times and the company's other newspapers, television stations, and new media properties on defamation, privacy, news gathering and related issues, and he frequently litigated media and commercial cases. He has taught media law at Columbia University School of Journalism, UCLA Law School, and Yale Law School. While working as a lawyer, Adam wrote occasional book reviews for the Times and the New York Observer and contributed to other sections of the Times. His work has also appeared in the New Yorker, Vanity Fair, Rolling Stone, Business Week, and the American Lawyer. So in other words, Adam is this rare combination of both journalism and lawyer. So thank you, Adam, for being here with us today, and would you all join me in welcoming Adam Liptak as moderator?
Thank you very much. You guys are in for a treat. We have an exceptional panel today on a really interesting case. I'm going to introduce the panel in a second, but I wanted to say just a couple words about the case, which is easily the most interesting case on the docket so far. Now, that's more a statement about the docket than about the case. It's a pretty good case on a very thin docket. It's a wonderful case journalistically because the facts are easy to explain. People will have immediate intuitions about which side they're on. And the facts actually present the legal issue in the case. So often at the court, you have what look like interesting facts, and it turns out that the issue is some second-order question about who gets to decide under what standard of review. Here you have the fundamental clash. So this case involves a program in Missouri that reimburses playgrounds that use recycled tires to make surfaces safe for children. So who doesn't like this program? It takes used tires out of landfills, and it keeps children from bruising their knees. And the Trinity Lutheran Church's playground would have been eligible for this program, but for one thing. And that thing was Missouri's Constitution, which says, no money shall ever be taken from the public treasury, directly or indirectly, in aid of any church. So the church applies for the program. By the criteria in the program, it does very well. People will give me comes in 5th out of 50th or something. It would ordinarily be eligible for the program, but is turned down on the ground that it's a church. Church sues, it makes free exercise and equal protection claims, and it loses in the lower courts at the motion to dismiss stage, and that itself is telling. This is a clean legal issue. Nobody disputes the essential facts, and the question is how you think about the religious liberty issues in the case. The church said it sought only to protect children of all faiths from injury, and that it could not use rubber in its religious work. There's a nice piece in the church's, nice passage in the church's opening brief, which I'll read to you. Including religious entities in the program would equally further the state's goal of keeping tires out of Missouri's landfills and fostering children's safety. A rubber playground surface accomplishes the state's purposes whether it cushions the fall of the pious or the profane. As I read that, it occurred to me that my own sins might require a double layer of cushioning. So let me introduce the panelists who will elaborate on the superficial characterization which marks so much of my work in describing this case. They are, in order to my left, David Cortman, who's Senior Counsel and Vice President of U.S. Litigation with Alliance Defending Freedom. David argued Reed against Town of Gilbert, which may be the most important free speech case, another part of the First Amendment, issued by the Roberts Court, and he won that unanimously. He's the lead counsel in this case, and he will argue it if the court ever gets around to scheduling it. Kevin Marshall is a partner here at Jones Day. Before that, he worked in the Office of Legal Counsel and served as a law clerk to Justice Clarence Thomas. He filed an amicus brief supporting the church on behalf of the Institutional Religious Freedom Alliance. And Dan Mack is director of the ACLU's program on freedom of religion and belief. Before joining the ACLU, Dan was a partner at Jenner and Block. He filed an amicus brief supporting the state, saying not only that the state may choose not to subsidize the church playground, but that it's barred from doing so by the federal Constitution's Establishment Clause. So let me go down the line in a kind of lightning round with a little bit more context and elaboration. Then I'll have a bunch of questions for the panelists. We'll discuss things among ourselves and turn to your questions. David?
Thank you. I appreciate, Adam, you coming here, the introduction. Thank you, everybody, for coming. Adam's superficial comments are accurate in this case. Normally, they're not, as he tells you. There's always something deeper going on in the case. Here, there's not. Pretty much what he read is what's going on here. And that was the appeal, obviously, of the case to us. When we were first contacted several years ago from the church, and Trinity Lutheran Child Learning Center is the name of the preschool. When they come to you, you're always wondering when clients come to you, okay, you told me this, but what's really going on? What's the facts I don't know about? What's behind those facts? Well, there's nothing behind those facts in this case, and I think that's one of the reasons it makes such a great case. And that is, there's a church-run preschool, and it's actually pretty popular in the community. It has about 90 children that attend the preschool, and 95% of those children don't attend the church. There's no affiliation with the church. So it's open to everyone in the community. It's open to children of any faith. And not only that, the playgrounds that they use are open to everyone in the community, not only to the children who go to that preschool. They actually leave them open for kids in the neighboring community to come and use at their pleasure. And so they actually had an idea a few years ago to upgrade their playground. And so they changed some of the climbing facilities, the monkey bars, all those things we remember as kids, and out about this program. And so they thought, what a great idea. When we're upgrading our playground, we'll make sure that the surface is actually safer, and we'll get this, we'll apply for this reimbursement that'll make the pour-in-place rubber is what they use. And so they fill out the application, and they have to agree to do some teaching on recycling programs and to do some advertising and some different things. And they hand in the application. Then they find out that they're ranked number 5 out of 44 applicants. And so that was fantastic news. They thought they were going to get to participate. But then they're told that, well, after reading through your paperwork and realizing that your preschool is affiliated with a church, that you cannot participate because of the Missouri Constitution, sometimes referred to as the State Establishment Clause or the No Aid Clause or the Blaine Amendment, as some people refer to it. And so what's interesting about it is they come to us with these facts, and we're thinking, okay, that's fantastic, but what else is going on? Nothing else is going on. So we file a lawsuit. We allege equal protection and free exercise violations, and it gets dismissed right out of the gate, right on the pleadings, no discovery, and we're thinking, well, that's terrible. We thought we had a good legal case, but the standard is that it failed to state a legal claim, so that kind of hurt. You know, we've been doing this law for like 20 years. We have a whole team of attorneys, and we didn't even state a legal claim, and so that was pretty bad. So we go up on appeal and end up losing again, but this time it's a 2-to-1 vote, so at least we convinced one judge that we had a legal claim, and so it got a little bit better. And basically the courts ruled that the state is allowed. There's what's called play in the joints between the free exercise clause and the establishment clause, but the state is allowed not to have the church participate in this program, and it doesn't violate the federal constitution. And so we filed an en banc appeal, which basically asked the entire Court of Appeals, and we had a 5-5 vote, and so we were going in the right direction. We went from no judge to one judge to 5 judges who agreed with us, but still didn't take the case because you need a majority, and that's when we applied for the Supreme Court to hear it. So hopefully that number will keep increasing, and we'll get at least 5, if not more, at the Supreme Court. But what we're looking at here is the reason we think the case is so important is not only is it a wonderful concept about protecting children, but we think it's an extremely important principle. Out of the cases that were mentioned before that we've been involved in the past several terms of Reed versus Town of Gilbert, the Town of Greece case, and Zubik and Hobby Lobby and Conestoga, we think this case is also important because of the principle that when you have this program, that in our opinion is just for health and safety, health and welfare. You hear all the time about everyone in the public, that a church shouldn't be discriminated against or shouldn't be excluded merely because of who it is. So everybody gets to participate in this program, all not-for-profits, so they're within the group that are allowed to participate. They meet the criteria better than almost everybody else who applied. They're in the top 5 of 44 applicants, but then solely because they're associated with a church or religious organization, they're just completely pushed out of the program. And so we think that's a dangerous principle to be allowed to be fostered. And that is that if the government's job is for the health, safety, and welfare of its citizens, we believe it should be for all of its citizens. It shouldn't matter who you are. You shouldn't say, well, we want your kids to be safe, but if your kids happen to be playing on a playground associated with a church, it doesn't matter if they're not as safe. It doesn't matter if they get hurt or if they scrape their knees. And that principle carries over not just to playgrounds, obviously, but to any benefit like that, any government program, whether it's police or fire, ambulance, if there happens to be natural disasters and the government comes in and helps, whatever you may have, we think that principle is one that should not be allowed to stand, and we think it not only does the Establishment Clause not justify it, but the Free Exercise Clause doesn't allow it.
David?
Thanks. I want to start with one of the points Carrie made, which is the broader context here. The United States right now is locked in the middle of a pretty heated debate about the place of religion and religious people in society. And that in turn is part of a broader debate about how society can give equal dignity to all people. So you, of course, think about the Obergefell case, not just the opinions, but some of the fallout with the wedding cake wars, or the case you probably think of as Little Sisters of the Poor, but we at Jones Day like to call Zubik, involving the contraceptive mandate, and even the bathroom war is going on right now. And that's just the civil part of the debate. That's in court where people more or less behave themselves. Outside of court, it's even uglier. I saw some recent comments by the chairman of the Civil Rights Commission, whom one might think would be a reasoned voice in this, but appeared to denounce as hypocrites and bigots, both, all people who hold to traditional Christian doctrinal teachings. Now, I raise that in a kind of paradoxical way because Trinity Lutheran Church is not raising those issues directly. They're not getting into that. And so you could ask, as we wrestle with these things and we have so much heat and even a little light over these momentous questions, why should we care whether a church in Missouri can get a little bit of help repaving its playground or paving its playground? And that's because, paradoxically, how the court answers that question will have huge implications for this broader debate. And to explain why, I want to start with another case called Locke versus Davey, which is very much at issue in the briefing. It's from 2004. Washington State had a program where they provided college scholarships, broadly available to anybody. But you couldn't get a scholarship if you were going to use it to get a degree to be a minister. The Supreme Court said that was fine. It said the Establishment Clause did not require Washington State to exclude these kind of degrees, but the Free Exercise Clause didn't bar them from excluding those kind of degrees. Now, so why was that exclusion consistent with the Free Exercise Clause? That is a very good question. And unfortunately, the majority opinion was written by Chief Justice Rehnquist, who was very good at getting majorities but didn't always put a premium on clarity or logical consistency. So to understand the issue, it actually helps to start with the dissent by Justice Scalia. Now, Justice Scalia pulled from several landmark Establishment Clause decisions of the court in Free Exercise Clause cases for the following rule, that if a law burdens religious exercise and is not neutral toward religion, it's highly suspect. He even went back to the Supreme Court's very first modern Establishment Clause case, a case called Everson, as support. That had to do with a busing reimbursement program. And the court in Everson said the following, which Justice Scalia block quoted: New Jersey cannot hamper its citizens in the free exercise of their own religion. Consequently, it cannot exclude them, because of their faith or lack of it, from receiving the benefits of public welfare legislation. Fairly straightforward rule. Justice Scalia had a good amount of support for it in the precedent. So what did the court do? Only Justice Thomas joined him. It was a 7-2 decision against that. So why? Well, I'll just tell you what Chief Justice Rehnquist said, that Washington State was pursuing in good faith a historical and substantial anti-establishment interest in not funding the religious training of clergy. And he evoked some history from the founding, which we might hear more about later, and for the following conclusion: if any room exists between the two religion clauses, which means if there's state action permitted by the Establishment Clause that's not prohibited by the Free Exercise Clause, it must be here. Well, that's great for that case, but it's pretty narrow and fact-bound. So one could reasonably ask, what else might squeeze into that room between the clauses, and where's the line? Well, Justice Scalia, as is his wont, asked those questions. He said, okay, well, could Washington State exclude ministers from health care benefits, Medicaid, Medicare, Social Security benefits, disability benefits, unemployment benefits? Could they bar ministers from using the public roads on their way to church? Chief Justice Rehnquist's answer was, religious instruction is different. So we have no idea, or not very little idea from Locke versus Davey, what happens in the next case. And as an aside, if you're a fan of judicial minimalism, Locke versus Davey is probably not your best exhibit. It's something you need to wrestle with about the kind of chaos that's been created. But the reason that the playground at Trinity Lutheran Church matters is now the court is going to be forced to answer the questions that it stirred up in Locke over a decade ago, but didn't try to answer then. And the answer could be a big deal for this broader debate that Carrie mentioned and I mentioned at the beginning. As another aside, I think we can be glad that it's about recycled tires and playgrounds and not directly about all these contentious issues, because maybe we can have a somewhat reasoned discussion about the principle of the thing. And here's what the principle is. If you can exclude the religious from a broadly available subsidy for resurfacing a playground simply because they're religious, as David said, from what public benefits can you not exclude them? And to me, the case is actually even more fraught than that principle because of the facts here, which Adam alluded to. So Missouri does not consider all playgrounds to be created equal. That's because it has limited funds. So to allocate the funds, it ranks the applicants. As you heard, there were 44 applicants here. Only 14 of them were able to get grants. Trinity Lutheran ranked 5th. Because Missouri excluded Trinity Lutheran, it gave the award to the applicant ranked number 15. And so what that means is that by Missouri's own criteria for fulfilling the secular purposes of its program, it has funded a less qualified applicant. Missouri, in excluding the religious, has made its program less effective. And so with these facts, we're very far from just something like using religion to break a tie, to borrow from another area of law. What we have is Missouri willing to harm itself so that it can harm the religious. And by my lights, we went into this in the amicus brief, that's the very definition of irrationality. Or one might even say animus, or as non-lawyers would put it, spite. And for that reason, the exclusion of Trinity Lutheran should fail under any standard of review. There's a lot of discussion of that. And consider a hypothetical. Let's suppose that Medicaid excluded anyone who'd ever had an abortion. That, I think we'd all agree, would be pretty dubious under existing precedent, and there's actually a Supreme Court case that suggests as much in dicta. Well, let's change that hypo just a little bit more. Let's say Medicaid, instead of being an entitlement, gets an annual appropriation. So you have limited funds, you have to ration care. How do you do it? Let's make a list of poor people who would otherwise be eligible, and we'll rank them based on the extent of their health care needs. Well, then let's take someone who makes the cut and exclude her simply because she had an abortion. Would that not be even more dubious than my first hypothetical? Well, that's this case. And that's why if Trinity Lutheran loses, it's very hard to see where the parade of horribles stops marching.
Dan, I'm guessing you may have heard one or two things you disagree with.
Not a thing. I agree with everything that's been said thus far. I think this is going to be a very important case if the church wins. If the state wins, I think this will be par for the course and fully consistent with what the court has done over time, and actually fully consistent with the origins of the Constitution and the founding of this country. If the church wins this case, it will effectively undo the state constitutional provisions in over 3/4 of the states out there. 39 states have provisions just like this, and there's a reason why they have them. It's consistent with this long-standing view that dates back to the founders that prohibits the government from doling out taxpayer funds, direct cash grants to houses of worship. And that is a rule that it has animated the formation of the First Amendment, and specifically the Establishment Clause. And it's a rule that is not only good for government, but good for religion, as the founders, and in particular James Madison, thought. This is a rule that protects unwilling taxpayers from funding houses of worship to which they do not adhere. It is a rule that protects church autonomy. It prevents churches from fighting with each other over government subsidies. It helps protect against dissension, sect versus sect, denomination versus denomination. It prevents churches from feeling the need to tailor their faith, their doctrine, in a way that will be more appealing to the government. And keep in mind, the program that we're talking about here, as Kevin mentioned, is not one that everyone gets. It's not the case that if you have a playground, you get this. Only 14 of the 44 applicants got one of these grants, so that less than a third of the applicants got one of these grants. And so even if there is not the specific details of the infighting going on here, this is a bright line rule that helped animate the First Amendment in the Bill of Rights. And the court consistently has adhered to this rule. This is a bright line rule that the Supreme Court has consistently warned about. It has never allowed direct cash grants to houses of worship. There's a reason. It's because it falls, as the court has said, precariously close to the original object of the Establishment Clause. Now, under our law, we treat religion generally and houses of worship specifically differently. The First Amendment treats them differently. And this is a long-standing tradition. And we treat them differently pursuant to the Establishment Clause and the Free Exercise Clause. How do we do that? Well, on the one hand, houses of worship get extra protections. There's more hands-off requirements on the government when it comes to houses of worship. There are additional benefits that houses of worship get under our law. And at the same time, there are additional constraints on what the government can do when it relates to religion generally and churches and houses of worship specifically. It is a two-way street, but in this case, the church wants to have it just going in the one direction. And not only does the church want to undo this long-standing constitutional rule that bars these direct cash grants, the church wants to go much further. Not only does it say, is it permissible for the state to fund this sort of thing, but it's actually required. This is a must-fund rule that has absolutely no historical pedigree and no historical precedent. So even if you disagree with the brief that we filed, even if you think that there are some certain circumstances in which this sort of thing would be permissible for a state to choose to do, there's a huge additional step to say that not only is it okay for a state to do it, but the state must do it. And that's where Locke comes in. And I'm glad Kevin summarized the facts of Locke, so I don't have to. But it's interesting that he focused on the dissent. You'll see almost all of the arguments that the church is making in this case were made by the losing side in Locke and were raised by the dissent in Locke. The passage that was cited is a passage, as Kevin pointed out, that Justice Scalia quoted at length in the dissent in Locke. And there is a line that immediately follows that passage from Everson, in which it says, we're not saying that the state of New Jersey in Everson had to do this, of course. We would never say that. And that's the line that's left off. So you just have to keep in mind here that even though this is certainly an appealing program with noble aims by the state, there are special rules that apply to houses of worship and special rules that go in both directions. And I think that anyone who thinks that we should get rid of one half of those rules has to think about whether they want to get rid of the other half. I certainly don't. The church has every right to make capital improvements to its facilities, but it can't expect and force taxpayers to pick up the tab.
David, you may well share Kevin's doubts about whether Locke was correctly decided or not, but in your brief you accept it as settled law. How is Locke different from your case?
I think Locke is extremely different on many different fronts. First of all, Locke was a decision not based on who the applicant was. And that's the biggest problem we have in this case. This is what I would call status-based discrimination. It's the most odious form, and that is, it's not whether you're qualified for the program, it's just who you are. We don't like who you are, and so you get excluded. So, for example, in Locke versus Davey, for the scholarship program, it was fine that the student went to a religious school. It was fine he was religious himself. It was fine that he took religious classes. He could take any religious major he wanted. The only thing he couldn't do is take one major, and that was to be a clergy person for devotional theology. They called it the study of devotional theology. What the court said, that program went a long way to include religion in all those aspects I just mentioned. It was one narrow way of one major he couldn't take, but could take whatever else he wanted. Here, in contrast, you're completely barred at the door. There's no religion involved at all. If you're religious, you're excluded, even if you qualify for the program, even if you do better than everyone else. And so it doesn't go a long way to include religion. It just completely prohibits it before you're able to get in the door of the program.
And what do you say to the point that this is not, as you said, a program of general applicability, but a program that's quite selective?
Well, it's selective in a particular group of people of which this church was a part of. And so there's a difference between saying we want a specific, for example, all public schools can be part of this program. Well, then the church has no right to say, well, gee, I want to be a part of this. But when you define that program to include a certain group of citizens, and that, for example, here the church or religious people are in that group, then it doesn't make any sense to say, well, you do qualify, and you're in the group that we want to allow participate, we're going to exclude you based on who you are. Because we're religious, and I think it's an interesting point to what Daniel mentioned, I think this case actually flips the Establishment Clause and the Free Exercise Clause on their heads. So not only does it not provide protection from the government, which is what the clauses are supposed to do, it actually allows those clauses to be used as a weapon. It says, well, we're not going to prefer churches. We're not even going to treat you neutral or equally to everybody else. We're going to treat you worse than everybody else because you're a church. And there's certainly nothing in the Constitution that supports that theory.
I also think that an additional difference, and I don't know how it's going to play out, is the history. So in Locke, you had the Madison's Memorial and Remonstrance, one of the most famous precedents for the free exercise clause. And Madison wrote that to object to a Virginia bill to levy a special tax to fund teachers of the Christian religion. So Chief Justice Rehnquist was able to point to that and say, boy, that's kind of what would happen here if the scholarship were used for a degree in devotional theology. And even if the Establishment Clause doesn't require a state to exclude those sorts of degrees, boy, they at least ought to be allowed to do that. Then Justice Scalia had arguments for why Rehnquist was using law office history. But it was a very specific example that he was able to hold on to. And there's not as clear a precedent here, which doesn't necessarily decide which way the court will go on what the history says, but it makes it a different case.
Dan?
So Locke is important. I think much of this case is going to turn on what Locke means or what Locke doesn't mean. I think a lot of the argument is probably going to focus on that. I want to just talk about two quick things. One, the similarities, and two, the differences between this case and Locke. Obviously, the church wants to limit it to its facts and to the particular narrow circumstance of the funding of religious education. But if you look at the opinion and the reasons why the court thought it was permissible for the state to do what it did, it goes beyond that. The court was expressing a concern in Locke, and remember, a 7-2 court with Rehnquist writing, was expressing a concern over states' ability to protect against establishments. And they talked about what is an establishment, and more specifically, what did an establishment mean to the founders. It is beyond a doubt that an establishment to the founders meant something more than merely funding education of clergy. It meant funding religious institutions. And in fact, the memorial and remonstrance is addressed not just to the funding of clergy and their education, but also the support of clergy and churches, okay? And the state constitutional provisions that the court relied on in Locke, it said, look at this long history of states doing this. The federal government did it and the states did it. Every single one of those provisions that the court relied on, it lies in a constitution that also prohibits this sort of funding. It is the same anti-establishment concerns, and they go far beyond the funding of clergy. Now, how is this case different? I actually think the state's case in Locke was even easier. The state's case here is even easier than that in Locke. And why? There are a few differences between Locke. Well, number one, Locke involved funding that the Supreme Court had said was already permissible because it was indirect funding. In Locke, the funding was state money for scholarships. It goes to the person, and then the person gets to choose where they put the money.
That's actually not correct.
How so?
The money was given to the school
right,
first.
Based on.
So if we're going to be formalistic about it, then they would send it on to the individual.
Based on the individual's preference, right?
The direct funding with private
choice. The court
choice.
is not going to. The state there was not going to give money to a school that a student was not attending, right? It was up to the student, and the decisions relied on were the indirect funding cases. Here, and the court had already said that's okay. The court said if Washington State wants to do that, wants to provide that funding, they can. Here, the court has never, ever said that the state can provide direct cash grants to churches. So that's number one. Number two, the institutions at issue there were religiously affiliated institutions. The institution here is a house of worship, which is treated differently in many respects under the law. And three, the aid there was available to any student who qualified. This is something we've already talked about. Whereas in Trinity Lutheran, in this case, it's not available to anyone who applies. It is a limited discretionary program. So there are actually reasons that cut even further against the church in this case when you compare it to
I see people are eager to respond. Let me just maybe sharpen those points a little bit and narrow them. A two-part question. What work does the Establishment Clause do? Do you agree with Dan that it bars direct cash grants to churches? And is this akin to a direct cash grant to churches?
Yeah, it's a good question. It was actually what I was going to respond with, is that the Establishment Clause does not. It's interesting, the Supreme Court has never, in all of its Establishment Clause cases, over the decades has never said that the Establishment Clause bars any funding to churches. Never, ever said that. And as a matter of fact, there are dozens of programs all over the country for social services where churches do get direct money grants when they help feed the hungry and the poor and all the great social welfare programs. Churches are involved and under Dan's theory, those would all be unconstitutional. So what the Supreme Court has said is that what they don't do is fund to religious organizations for religious activities. And that caveat has been missing from Dan's description, and that's the most important of the Establishment Clause. So when you have secular activities, I mean, how much more of a secular activity can you get than not only a playground, but the floor of a playground for kids to have a safer fall? And so it's clearly secular activities here. And so there is no prohibition. And the Everson case, which was one of the original Establishment Clause cases that is cited all the time for the standard, I just want to read one sentence of what the court said. We must be careful in protecting the citizens of New Jersey against state-established churches, which is what Dan is talking about, to be sure that we do not inadvertently prohibit New Jersey from extending its general state law benefits to all of its citizens without regard to their religious belief. This is the main Establishment Clause case cited by everyone, and yet it specifically says exactly what we're talking about. What we don't use the Establishment Clause for is to single out religious people or religious organizations and treat them worse than everybody else.
Paul, the debate here is pointing to another interesting aspect of this case, which is Dan, as far as I know, is correct to say the Supreme Court has never directly held you can give money directly to a church. But David is also correct to say the Supreme Court's never said you can't. So then to get to your question...
What does the Establishment Clause tell us?
We're trying to avoid an establishment of a religion. We're trying to avoid, to simplify a little bit, an established church. And that's the way the court has approached these kind of questions. So one simple line is the church getting money as part of a generally applicable program, or is it getting it as part of a special tax to fund the teachers of the Christian religion? A good example, I think, is a case from my perspective, dark days of the 1970s and 80s in this area of law, a case called Nyquist. And there, I think it was a direct grant. It was a reimbursement for construction costs for colleges. Supreme Court struck it down, as it did a lot of things back then, but it did it by a vote of 8-1, pretty overwhelming. And so why did it do it? Well, and the money was going to church-affiliated schools.
You're thinking of Tilton.
What?
Tilton.
I thought it was Nyquist. It's
Nyquist
Tilton
was
as well.
Secondary.
Okay. But they didn't say, don't give money. What they've essentially said is, we don't think this is neutral. We think this is a clandestine establishing of a religion. Why? Because the money could only go to private, nonprofit schools in low-income areas, and it turned out they were all Roman Catholic. Right. So that's why the court has said direct funding is a source of special concern. It makes us raise an eyebrow. We look closer. That's entirely correct. Even Justice Thomas has said that. That doesn't mean it's a per se ban. It means if you have direct funding and without private choice, we're a little more suspicious. But that doesn't mean it can't be done.
But if we have direct funding for a non-secular, a non-religious purpose, how do we know that money is not fungible, that paying money to one account allows the church to have more money in its religious account?
Well, that's a great question. The Supreme Court has already addressed that, and there's two different answers to that. One of them is the Supreme Court has said over and over again, just because money is given to a religious school or organization that may free up other money to be used for religious activities is not a violation of the Establishment Clause. The other principle that the court looks at is what they call diversion, and that is, can this fund, this benefit be used? Okay, you say it's for a secular purpose here, but can you take it then and secretly use it for something religious? It's called diversion, and the justices have different views. What's great about this case, there's not only no diversion, there's no possibility of diversion, which several of the justices look at. And the reason for that is this is a reimbursement grant. What that means is the church has to go ahead, pay for the playground, make sure it's put in, send the bills to the government, and then the government reimburses the money. So you can't use that money for anything else because it's already used for that secular purpose of the playground surface.
Does that
I'll
sound
say
right,
that
Dan? Dan seems eager to jump in, but there's time for everybody.
Yeah, so on that question, we've heard, in the briefs it calls this a secular grant, a grant that is wholly secular. 2 points on that. Number one, it doesn't matter because it's a cash grant from the government to a house of worship, which has never been allowed. But number two, let's remember what we're talking about in terms of this school. The school is a ministry of the church. Religion is infused in everything it does. It integrates religious teachings in all aspects of the preschool, and it designs its programs. As it itself has said, it designs its programs not only to teach the gospel to children of the church as members, but to bring the gospel to non-members, the gospel message to non-members. So this is a playground. All it is a playground. But if it were improved at taxpayer expense, it could be used in connection with any religious purpose related to the preschool, to the church's vacation Bible school, to its Sunday school, or any other youth-oriented program. It's to say it's just rubber is like saying a government lumber program is just about wood, and it's perfectly fine for the government to pay a church for lumber to build its sanctuary. It's not what the material is made of. It is the character of the recipient and what our constitutional system has said about that recipient. It's treating it differently in multiple respects throughout our history.
I think your question also points to how the case might turn out. Dan wrote a great brief, in some ways the most coherent on that side, but it also stakes out a pretty extreme position. What?
Faint praise.
Yeah. No, I enjoyed reading it. But I can see the court taking some from his brief and saying something like this. It is true this is direct funding, and we get especially concerned when there's direct funding, especially when there's not private choice. But we think this program is okay, notwithstanding the concerns. And it's okay because it's reimbursement, so the money can't just directly be used for something else. It's a one-time grant, and it's for rubber on a playground. And we are not going to address, perhaps as Chief Justice Roberts, what might be the result in a case involving direct payment to a church without private choice that involve different facts. Under these very specific facts, this is okay. That's not the result Dan wants. But I'm saying that the concerns he flags in his brief could lead to that kind of a result.
And, there's a couple things. We talk about the principle that's going to be established. I mean, look at the principle. What is the difference when the government provides fire and safety or ambulance services? So the principle that Dan proposes, other than the form of payment, whether one's through a specific grant or general taxes, it's the same principle of saying, look, we have these programs for the health and safety and welfare of everyone, but if that church religious preschool is on fire, we're going to let it burn. If someone's breaking in, we're not going to send the police. If someone's hurt, we're not going to send the ambulance. If we found out that all the buildings on the block were built with asbestos and the government says we're going to remove that, we're going to let the kids at the preschool get cancer. I mean, that's the principle that's applied here. And there's no line drawing between whether it's rubberized surface for a playground, whether it's the police or fire department coming, and that can't be a constitutional principle. And so if we say that it's okay to do this, then what is the principle upon which it's not okay to send the fire or the police?
What is that principle, Dan?
So it's not like that at all. It's not like police or fire protection for a bunch of reasons. Those are generally applicable universal entitlements that everyone gets and everyone depends on and expects to get. Here, almost no one got this, fewer than a third of the applicants. That kind of aid is in-kind aid. In other words, they're paying the salary of the police officer. They are not paying the church.
So let me ask you a question before you move on that point, because I think that's a great point. What if the government program paid Department of Motor Vehicles workers? So they bought all the rubberized surfaces, kept it at their facility, and then just paid workers out of their general tax revenue and said, you go install this. Would that be okay under your theory? So no money going to a church. It's the same type of benefit. The DMV workers go and bring the surface and put it in themselves. Would that be okay?
And everyone gets it. Well, because they don't have enough to give to everyone.
Well,
See, that's one of the problems
But the government doesn't have an unlimited supply of everything. Everything is limited.
Exactly.
So under that theory, then no government benefit. There's no unlimited
But
funds.
the same stuff is available on the free market. So if they don't have the government workers come and put it in, the church could go and buy it.
Exactly, sure. And that's one of the things that again, the founders on up have mentioned. Churches and houses of worship should be funded and supported by their adherents, not by taxpayers who don't agree with their religious tenets. Now, on this question of health and safety issues, the Nyquist case, which Kevin was bringing up before, raised some of these important issues. Okay, in that case, there were direct grants for an incredibly worthy cause. It was to help with the maintenance and repair of facilities, and it specifically said for the health, welfare, and safety of children in failing schools in low-income neighborhoods. And the court didn't for a moment question the importance and the value of a program like that, just as I'm sure the court will not question the value of Missouri's program here. And they said, yes, absolutely, there's an interest in preserving the health and safety and in the educational environment for all school children. But the court still struck it down. And the court struck it down because it said, these are payments, direct payments that are going to the church, and there's no restriction on how they can be used, and we don't think it's possible, the court said, in a situation like that, to even impose those restrictions. And then the court said even money that goes for the heating and lighting costs that will subsidize these facilities, these religious schools, even that money will have the result of advancing religion. And it's worth going back to that opinion. The court then reiterates some of the broader themes that have been animating this rule over time, which is the concern about when the government gives out this money and doles out the cash, competition among sects, continuing political strife over aid to religion. That's the kind of thing we're trying to avoid.
Yes.
But the problem with that case is it was only for religious schools. And when you look at other cases under the Establishment Clause that all schools were allowed, it was upheld. So Everson and Allen and Reagan and Bowen and all these cases and on, the government under the Establishment Clause, the court upheld those programs. And the difference is Nyquist was only for, as Kevin mentioned, was only for religious schools. That's the preference you're talking about. But when it's in a program like this where everyone gets to participate, and even if it's a narrow group, don't forget that the church was still part of that group. And what we're doing is we're saying, because of, and this is, I want to go back to this, because of who you are. So the Establishment Clause now means that we're not going to protect religious people or religious organizations from the government. We're going to allow the government to discriminate against them and treat them worse, not because of anything other than who they are. And I think that is not what the Establishment Clause nor the Free Exercise Clause is meant to allow or protect.
Let me ask you guys a question based on the constitutional text, which the state thinks favors it. The state says, the words we're looking at are Congress shall make no law prohibiting the free exercise of religion. How does not getting rubber prohibit you from free exercise?
Well, it's the same question of, for example, McDaniel versus Patty, which was a case about a minister who wanted to be a delegate to the state constitution. And basically what they said is, well, anyone could be a delegate to the state constitution, but ministers can't. Well, he's free to be a minister. He's free to live his life and to preach and do all these things, but this benefit of being a delegate was taken away based on who he was. And the court said, 9-0, that that's impermissible status-based discrimination. So there's a difference between, sure, you're free to exercise your faith, but are you being discriminated against? Are you being singled out because of who you are? And the Supreme Court has said over and over again that that's impermissible, even though they're otherwise free. It's still a penalty based on your religious status.
I see both of you want to talk. Why don't we go in order?
I was just going to point out the additional constitutional text we ought to think about, which is law respecting an establishment of religion. So it's very fun to get deep into these cases and all these doctrines, but if we step back and look at the tire recycling playground program, we ask, what religion is being established here? Or is even religion in general being established here? You look at the 14 grant applicants. Do we think Lutheranism is overtaking Missouri? I don't think so. And one way you can know that is that the position Dan is staking out is one that Missouri is not claiming. They're not claiming the Establishment Clause requires them to do this here. The Eighth Circuit didn't even entertain it. So their position is, I think, logically weaker, but more in tune with the actual text.
So, and let me be clear about that position. The state didn't need to take it, and the court doesn't need to address anything we said in our brief. If the court agrees with the state that it had the room for play in the joints, it doesn't need to get into the hypothetical about what if the state actually had chosen the other direction. So it may be that the court doesn't get into that because they don't have to. But on the comparison to cases like the ones mentioned, McDaniel, so that was a case in which there was a ridiculous rule that excluded clergy from being delegates to a state constitutional convention. And the argument that you just heard here, and much of the argument that's in the briefing, was an argument that was made and absolutely rejected in Locke. And so the comparison to McDaniel is a comparison that was inapt, as the court said in Locke. It's one thing to say you cannot participate in the political process. It's another thing to say that you just can't get a handout from the government, which is what the church is asking for here. And the court in Locke described this whole area of funding as something that at most imposes a relatively minor burden, and said the state's disfavor of religion, if it could even be called that. So there's a great difference between telling someone they can't participate in the political process and telling them that they don't get cash from taxpayers.
This case would have been Locke if Locke would have said, everyone gets a scholarship but Christians. That would be this case in the context of Locke. And that's why Locke is not on point. It's not even close. I realize it's a similar type of arguments being made, but Locke didn't say that. It wasn't based on who he was. And as I mentioned before, there was inclusion of religion all the way through the program. But if Locke had said, every student who qualifies, and that was a qualification too, it wasn't for all students, you had to have the right grades and the right income status, so it was a smaller group of people, but every student who meets those qualifications can get this scholarship except for Christians. It would have not come out the same way, and that's this case.
Well, that's absolutely not the rule here. It's not everyone gets the money, but
in that group,
but Christian churches, it's houses of worship across the board.
All right, any people of faith.
Let's not.
Let's follow up on that any people of faith point, and we're going to turn to your question soon. But I was intrigued by one dispute in the briefs on the equal protection claim, and the question of should the court exercise more searching scrutiny, strict scrutiny? Should it look at the case more carefully because there's been discrimination against a disfavored group? And David's brief, if I'm reading it right, says that yes, because religion as such, not a particular sect, but religion as such has been disfavored. And that struck me, but I'm no expert, that struck me as a novel argument. I understand that if you're going to discriminate against Christians or Jews, that warrants heightened scrutiny. But does discrimination against religion as such warrant heightened scrutiny?
Sure, because otherwise what you would say is that when if free exercise clause protects religion, it would only be certain religions. So it doesn't only protect certain religions, it protects all religions. And so there are two types of religious discrimination. One is favoring one religion over another, which is what you're talking about. And the other one is just getting rid of all religion. And I think that would be just as odious, and that's the argument made in the brief. And I think the court has made that clear, religion as a class. It doesn't say only certain religions in its case law. It says religion as a class is protected status, and that is all religions.
And you get protected status or often, or at least in part, because you're politically powerless. Is it your contention that religious groups in the U.S. are politically powerless?
These days, it seems to be yes. Okay. But no, that's only one factor. And what they look at is historically. Have religions historically been oppressed? Absolutely. Have they been in this country? Absolutely. And that's the whole point. It's not just majority or minority religions, it's all religions. And so that's one of the factors, but seemingly more and more these days.
Let me conclude my question. Go ahead.
I just want to add something to that. David is right that if you go through the cases, when the court gives a litany of suspect classes, they will often mention religion. I don't think there's a case that has applied the Equal Protection Clause in the way he's wanting it. And I've not thought it through as much as he has, but I have some misgivings over using the Equal Protection Clause for this purpose when we have two explicit provisions in the First Amendment. And one of the reasons I have those misgivings is what Dan mentioned. Essentially, be careful what you wish for, because if it's a suspect class, we have strict scrutiny. That would be strict scrutiny for laws disfavoring religion, but also laws favoring religion. So we're going to start having like the Fisher of religion. I don't know whether that's true, but I think it's a serious question. It's one reason I think the court's going to be inclined to rule in favor of the church on First Amendment grounds. So they don't have to get into equal protection. Yeah.
All right, one last question for me, a practical question. Briefing in this case was concluded on August 12th. Wasn't set down for the October sitting, wasn't set down for the November sitting. What's going on?
You got to raise the sore spot, right? That's the question. And the reason I say it's a sore spot is it's tough to prep for an argument you don't know when it's coming. The good thing is I still have a day job and I help work on all our litigation. But it's a great question. The case was granted cert while Justice Scalia was still on the bench. Hopefully, and we'll find out, I think, in the next couple of weeks for the December sitting, My hope and prayer is that it'll be set for December. But it's a good question. I mean, there's a lot of speculation as to why. There's a couple other cases, so we're not the only ones that were granted early that are still waiting. There's a few of us, hanging out there. But I really know it is a good question whether the court is considering the makeup of the court or waiting for the ninth justice to be sat.
Any other thoughts on that? All right, I'm told we have some microphones. We would love to turn to your questions.
Hi, Jonathan Embody, and I'm not an attorney, so I'm going to make the mistake of asking a question when I don't know what the answer is going to be. But, back to this question of the original purpose of the First Amendment, if we could go back in time and, say, talk to James Madison, maybe on a Sunday when he's attending church in the House of Representatives, what do you think he would say about this case?
Yeah, I mean, I think that's a pretty easy answer. I have a hard time believing that the founders would say, if you have this neutral program and it applies to everybody within the entire group, a small group, whatever have you, that the Establishment Clause that you're writing actually requires you to remove churches or religious people from that benefit. Dan has read a lot, I've read a lot. I just can't see him coming to that conclusion. I think it's inconsistent with everything the founders have done. And another side point, we hear a lot about the Establishment Clause and the free exercise conflicting with each other. I don't think that's historically accurate either. It doesn't make sense to me that the founders would have two provisions right next to each other that are in solid conflict. They wouldn't write a document that way. They're supposed to complement each other, and when you add the protections and they work in the same direction, you end up with the result that is really just a neutrality principle here.
Other thoughts on the founding era?
Your question raises just a good general question of what do you do with history from the founding when you're trying to answer a question today, because it's never going to be directly on point. So I'm not entirely sure what Madison would think. I think he would be in line with David. Dan has a different view, but coming back to his opening comments, I'll point out that his characterization of Madison's position comes from the dissents in Rosenberger and Everson, not from court majority opinions.
So the majority in Everson said the imposition of taxes to pay ministers' salaries and to build and maintain church and church property aroused their indignation. It was these feelings which found expression with the First Amendment. I completely agree with David that the two clauses in the religion clauses work hand in hand. I think we might have a different view of how they work hand in hand. But I think that the Establishment Clause is just as much a religious freedom clause as the free exercise. It protects the rights of conscience in all the ways that Madison and others thought.
But the key ambiguity in what he just read is, what does to pay mean? Is it in a way that has the effect of paying, or is it in order to pay? That's what the big debate's about.
It's right there.
Hi, my name is Ashley Sherman. I'm a student at Texas Christian University. My question is, does the fact that the playground is open to the preschool and the community play any role in this case?
Just makes the facts much better. The reason is a lot of this is atmospheric. People have these reactions to things of, oh, it's for a church, and so that raises that general position that Dan talks about, that, oh, money to a church is bad. Well, the court's never held that. It's what it's being used for. But the reason it matters is they look at, for example, is it being used for, as Dan mentioned, a religious purpose or a secular purpose. So that's just additional facts to show. It wouldn't matter if they didn't, let me start with that. But the fact that anybody from the community can come and use the playground shows this isn't just for a religious purpose, it's not being used for religious activities, and so it's just another one of those facts describing what the playground is used for.
I mean, let's face it, these facts are a very good context for you to make your arguments in.
They are, and we always tease, and I think Adam mentioned this before, if you could write your own facts, you couldn't write them any better. So this is a great case, we think, on the facts.
Maybe back there?
Yeah, Joe Cosby, I'm an attorney in Washington, D.C. And I'm interested in hearing the kind of undercurrent about generally applicable law, because of course it raises the scepter of the Smith peyote case. And what I'm hearing, I think, is that Kevin at least would say that something is generally applicable if it is a kind of a broad statute. It might not encompass or apply to the entire population. It might not be available to everybody in Missouri or wherever else. but it is something that is based on certain neutral principles. It's basically open to everybody who meets certain criteria. I think I'm hearing Dan say that general applicability means it applies to everyone, generally across the road. And I'm wondering if, one way to interpret the theory behind Smith is that, as a free exercise case, that particular prohibition, even though it was prohibited in a religious exercise, an exercise of religion, was actually something that was it was based on neutral principles. It was aimed at a specific policy in which you wouldn't even suspect that the legislatures were doing it were outlawing peyote because they wanted to get to a particular practice of religion. So I'm curious about what your different views are of what general applicability really means and how broad it is, and what its application would be in this case.
Dan?
So, first of all, I think Smith has done serious harm to religious liberty. It's
Amen. Look at that. We agree.
It's a ridiculous limitation on the free exercise clause. It goes way too far in limiting how someone can invoke the First Amendment for purposes of protecting free exercise. I think the question of general applicability is an odd one in this setting, because it is absolutely true that, as they argue in their briefs, that this is a rule that speaks to and about religion specifically. What's odd about that is that that kind of runs counter to what Smith was talking about. Now again, this is exactly the kind of argument that was made in Locke. In Locke, the plaintiff in that case said, this is a clear violation even under the Smith rule, because you're not prohibiting scholarships to just anyone. You're prohibiting scholarships to people who want to train in one field and one field only. You are singling out the religious field. You're still allowing scholarships for people who want to train to become doctors, lawyers, God forbid, but not ministers. And therefore, you're clearly singling out religion. And the court said that kind of analysis just doesn't really apply in a case like this because of the important Establishment Clause concerns that are at play. And remember, in that case, that was a situation in which the important Establishment Clause concerns were not even ones that the court said were required by the Federal Establishment Clause.
You raised a huge question, which was what does Smith mean, even apart from whether it's right or wrong? I mean, at the outset, how is neutral different from generally applicable? I puzzled over that, and I still don't know the answer. There have been lots of law review articles written on that. Is generally applicable a way of establishing neutrality? I don't know. So I can't directly answer your question, except to say that Smith seems to be getting at the question of whether what a law is doing is targeting religious practice rather than accomplishing some secular aim unrelated to religion.
And I could give the shortest answer. The fact that this targets just religion shows it's not neutral, generally applicable.
Okay.
Thank you. How is the TIRES program funded? Who all pays into that?
That's a great question. There's actually a fee added to every tire purchase within that year. So if someone purchases tire, I believe it's 50 cents a tire gets added onto that tire, and that goes into a fund, and then only the amount that's in that fund gets dispersed for that next year.
So that's a nice point for you, that the members of the church are paying into this program but not eligible to take out of it.
That's right. We mentioned that. That's right.
Hi, Walter Weber, American Center for Law and Justice. I have a question about the role of formalism in this case. Dan's articulating a principle which I remember from way back in law school, which is that there's a difference between direct grants and other forms of services, like in the police and fire services in the Everson case. But things don't have to be structured that way. You could have a town that would say, we're going to privatize our police and fire services, and they'll charge you and we'll reimburse you. And as I understand what Dan is saying is that would be okay if everyone got reimbursed. If that's his position, that punches a hole through there being an absolute bar on direct cash grants, because it would be okay. If his position is no, it still wouldn't be okay, because there'd be a direct payment. And you can pay everyone else back, but you can't pay the church back. Then the question comes up, well, can't any government that wants to discriminate against religion structure its services in a way that involves the payment of cash? I mean, you could have all the equal access cases, right? All the religious clubs, you have to rent the room from the school, but we'll pay you back except if you're a religious club. So where I end up with all this is one of a couple possible conclusions. Either the principle needs to be reshaped because it doesn't work, or it doesn't seem to tie up with the concerns underlying it, which is, I think, political favoritism entangling with religious favoritism. Or is there an obligation on the government's part to comply with the Free Exercise and Establishment Clause to structure its services in a certain way? Can a government entity defeat equal treatment of religious bodies by structuring its payments in a way that makes it a direct payment? And then they say, oh, I'm sorry, we're helpless. We can't pay you.
Dan, you want to?
Yeah, I mean, I can't imagine a government doing that, and I think that the sort of thing like police and fire protection is in a different category. And I see that you're trying to draw a line, a continuum, but that is something that is in the wheelhouse of a government's core mission. What even people who are the most anti-government, who feel that the government should be as absolutely limited as possible, think that the government, and maybe I'm mischaracterizing, maybe there are some people who don't think there should be police or fire departments, but think that at the very least our government should protect us from that sort of physical harm. I think when you're talking about a discretionary grant program, it is a very different animal, and I don't think that the government could turn the one into the other.
Go ahead. I was just saying, I just wanted to mention, I read something about Fairfax, Virginia, actually has a program that when you call 911 and the ambulance is sent, they have a program where they reimburse people for the cost of the ambulance. The question is, under Dan's theory, would everyone be allowed to be reimbursed but the person who got hurt at the church or someone at the church working? And I think that's a similar principle that would apply, because that is an interesting program that I was never aware of until recently, and I think that's the same principle we have here.
I think in Dan's position, and to a lesser extent, or a less clear extent in Missouri's, there is a double level of two layers of formalism, and they're either empty or incredible. So to take the first one, it's this direct funding rule. So let's use a fire alarm example. The city decides every building in the city needs to have a fire alarm. Well, you go buy your fire alarm, send us the receipt, we'll reimburse you. That apparently is bad if the reimbursement goes to a church. But if the city instead just buys a bunch of fire alarms and sets them out and says, come and get them, that's okay. I don't understand why that makes sense. And if there's going to be some non-evasion principle that makes the second one wrong, then why can't churches have fire alarms on the same basis as everybody else? The second level of formalism has to do with this houses of worship principle. You can't give money to houses of worship. That may be the ACLU just trying to limit the scope of its sweeping rule, but it's good to recall here that what we're talking about is a preschool within Trinity Lutheran and operated by it, but it used to be separate. It was its own nonprofit. So does that somehow make all the difference in the world? And we could solve this whole problem if Trinity would just spin off the Learning Center again, and then it could get its grant?
Kevin, assuming the Establishment Clause does some work, there has to be some line drawing, no? I mean, what does the Establishment Clause prohibit?
It prohibits establishing a religion, and the line that the primary line the court uses, or perhaps ought to use, is whether a program is neutral with respect to religion. Now that's easy to state, and there you could have a lot of factual questions in a particular program, Nyquist being one example. So formally, you have a program that's neutral toward religion. That's not the end of the inquiry. Let's look at how it actually operates, and are you actually favoring religion, a particular religion or denomination, in a way that looks like an establishment?
Who's next? Back there?
I'm just going to stand because I can't see you. Stephanie Acosta Inks. I'm an attorney. I'm a Simpson Thatcher Public Service Fellow and a mother. And so I just wanted to ask a question to Dan, but also just take one little issue with the fact that the rubber surfaces on playgrounds, as a mother and a lawyer who spends a lot of time on playgrounds, is kind of a big deal. It's not just about scraping knees, it's about like preventing brain injuries. So, it's a big deal. Our city's playground was recently redone, and it was huge. I mean, the outpouring of support to get the rubber in our playground from mulch was a really big deal. So just so you guys know, it's not just about scraping knees. Dan, you almost won me over, but I take issue, I go back to this fire and emergency services analogy because I think it's a good one. And I think, you talked about limited resources with the discretionary grant, but even the emergency services are limited, right? So to me, the analogy is more if there's 2 emergencies or 3 emergencies, and one is a church emergency, do you use objective criteria to respond who's closest, how big is the emergency, or do you say, no, that's a church, we're going to go to the secular, house or the non-worship facility? I mean, isn't that more of the analogy, or does that not strike you as right?
No, I mean, I don't think that a local government could or should make those decisions, could say you're a church, so we're not sending the fire department there at all. But I just think that is an entirely separate function of government than a handout, which is what's going on here. I think the protection of health, safety, and welfare is important, but even in cases where that's invoked, like the Nyquist case, the court has said that's fine, but we're not going to. I mean, the government could make every building as safe as possible if it wanted, but it doesn't have all the resources to do that. So I just think that the function of government when it comes to things like fire protection, police protection, is in a different category. It is not cash grant. It is, if it's aid at all, it's what we would call in-kind aid, but it's a basic function of government in a way that this simply is not.
We've got just a minute or two left. I think we'll take one last question over there.
Yeah, Brian Walsh, Civil Rights Research Center. So we've been talking about hypothetical programs, but what about one specific real program? U.S. DHS, Department of Homeland Security, since 2005 has had a program, the Nonprofit Security Grant Program, that makes direct grants to houses of worship, synagogues and others, in order to enhance security, specifically in the terrorism context. So my question is, that's been going on since 2005. Is this a distinguishable program? In what way is it distinguishable? What's your position, I guess, Dan, in particular, on that program? And has it been litigated already? And if so, what's been the result?
I'm not aware of litigation on that issue.
You just gave him an idea.
I think, again, there is a difference between the government providing security, providing added safety and protection, and providing money to do so. Again, we've seen many very well-meaning programs, but that doesn't mean that the government has free rein to spend taxpayer dollars to support them. So I think there are constitutional concerns.
Just to be clear, it is a direct grant program, though.
Right.
So
We'll defend that church if they take that program and get sued by the ACLU.
So if nothing else, we got a lawsuit out of this program.
That's right.
Really terrific, lively panel. Join me, please, in thanking them.
Well, I thought that was a great discussion. Thank you, Dan. Thank you, Kevin. Thank you, Dave. And thank you so much to Adam Liptak for facilitating such a rigorous conversation. Can you just join me again in thanking our panelists and moderator? Thank you. So we're going to take a 15-minute break, and we'll reconvene for our second panel on religious freedom in the Supreme Court. Grab some coffee, go outside, enjoy the view, and we'll see you very soon.